The recent DOMA, or Defense of Marriage Act decision by the Supreme Court of the United States, opens up a lot of individual tax questions for the coming tax year, as well as many past tax years. This short piece is an overview and summary of the individual tax return implications of the decision and the potential tax consequences and considerations from it. In the next 3 minutes, I'm going to share with you 8 important considerations related to the new decision for you and/or your tax clients. So get ready. There's much uncertainty currently as of August 2013. Much guidance is expected and needed from the IRS before the 2013 tax returns can be prepared in 2014. So the first point is simply this: many open issues and many more discovered each day. Expect much guidance from the IRS in the coming months and certainly before January 1st, 2014. What we do know definitively at this time is not very much, but highly likely from an income tax return standpoint is that same-sex couples who are legally married will be eligible to file joint federal tax returns, presumably beginning in the 2013 tax return to be filed starting in January 2014. After that, it gets more complicated, and there are many open issues, including the following points. When are same-sex taxpayer couples considered married for federal income tax purposes? Under what circumstances will the IRS allow the married filing joint status to be claimed? Factors are likely to include: does the taxpayer have a marriage license from the state? What state was the marriage performed in? What state did the taxpayers reside in during the tax year? And other factors. Another related issue that will certainly need clarity: how will the IRS treat same-sex couples who are legally married in states that recognize such marriages, for example New York, but subsequently reside in a state that does not recognize same-sex marriages, such as Florida? A big question and a new question resulting from the DOMA decision for same-sex couples and their tax return preparers: whether or not a couple should file a tax return that has married filing jointly as the status, even when they can. Marriage penalties, credits, and tax deduction phase-outs, and other factors may give a bad tax result or a higher tax result. So just because the rules provide that a couple can file married filing joint does not necessarily mean in all cases that they should. Can same-sex taxpayers who are now able to file as married on their federal tax return go back and amend prior year tax returns if married filing joint gives a good tax result? And should they file a protective claim right now to secure that right? A big question for sure. State tax return considerations under state tax return rules for those states that have an income tax, and 41 states have a broad-based individual income tax, and some of those states recognize same-sex marriages, and yet others do not. Those states that do not recognize same-sex marriages will likely wait for federal tax guidance, and even then may not follow the federal rules. As with most tax situations, the facts and circumstances are likely to be far more complex than any example simple tax situation fact pattern. And the open issues, even on the most simple fact patterns, are likely to see joint filing considerations, including but not limited to the tax filing status considerations, IRAs or individual retirement accounts, including contribution limits, cafeteria plan benefits such as medical flex savings accounts, and even the provisions under the recently passed Affordable Care Act or Obamacare and credits and subsidies. Accordingly, filing a joint federal tax return will affect other parts of a taxpayer's tax return, including the application of the tax rates, netting of capital gains and losses, and calculation of tax on Social Security benefits. Also, computation of adjusted gross income or AGI, and numerous other deductions and credit computations. In short, the new rule makes tax considerations much more complex, and there is no absolute rule for winners or losers. Each situation will be based on the facts and circumstances and will need to be evaluated carefully. Otherwise, you and your clients, or you and your significant other, could pay a lot more in taxes. Be better prepared and get all the information you can on the changes generated by DOMA, and make sure you get every tax benefit you and your clients deserve.